All right, my name is Stephen Mosley. I'm the coordinator for Student Integrity and Conduct here at the Annandale campus, and I've been tasked today to do a little refresher training to make sure that you feel equipped to sit on a formal hearing panel, and that is what we want to do today. I will, basically the quiz that you took is online, so I will go over the online version that you will see on the screen, and we'll just take it line by line. If you're here in the room today, I gave you a formal hearing training guide. If you have it, just wave it at me. Make sure we got it. Great. What we want to do before we do that is go ahead and go around the room and introduce yourself and your role here at the college, and maybe a little bit about your experience. If you've sat on a board before, just say, yeah, I've sat on a board before. And if not, well, we're glad you're here. So we'll start here to my right and go across the room to the 5 people here in the room.
Hi, my name is Lynn Hathaway. I am currently a student here at Nova Annandale, and I've actually never served on a board. I did do the training last semester, but never got a chance to serve on a board.
Great, Lynn. Glad you're here.
Oh, my name is Rosa Sherrod. I'm a counselor on the Loudoun campus, and I've never sat on a panel before.
Great.
Hi, I'm Kelly Akers. I work at the Loudoun campus. I'm a development advisor, SG advisor, and we did have a board last semester. I sat on it for one day, and the student was supposed to come for his first hearing, and he canceled, then it never came back up.
Hey, Jesse. We are going through introductions right now, and you missed the quiz, so you kind of got lucky on that one.
Cheryl Robal. I'm a counselor here at the Annandale campus. I attended the training last semester, but I have not sat on a panel yet.
I am Justice Horgan. I'm a counselor, and I'm not sat on the panel yet either.
And I'm Celeste Beck Smith. I'm the Dean for Business and Public Services here at the Annandale campus. And I've sat on more panels than I care to discuss.
Well, all of you, thank you for coming today, and I hope this is beneficial to you. This is the refresher training, and as part of the refresher training, this is what the online quiz looks like. We'll go over all the questions. If you took it here right now, the written version has one extra question, and if you really want to know the answer to it, we'll go over it. But let's take question number 1. Where can you find the student code of conduct? Yeah.
Okay, I know it's on the website, so the student handbook.
That's correct. On the website and student handbook. This one's very important because there may be some written handbooks out there somewhere. When I first came here in 2014, I used a written handbook. And the written handbook is totally different than our online handbook. The online handbook is what we use. It's up to date. It's current. So if you have a written handbook from 2015, or I think it was 13-14 was the handbook that I received, don't use that. It's out of date. All the information, much of the information there is no longer accurate, such as the timing for the difference between an informal hearing and formal hearing is no longer accurate. How we do academic misconduct, we used to do all of them here in the student conduct, Dean of Students Office. And now we only do major infractions of the academic misconduct, and there's a whole standard in the handbook of how that plays out. A couple of rules are different from the old handbook to the new handbook, so that's why I always encourage you, make sure you're using the most up-to-date information, and the most up-to-date information is on the website. So the answer to number 1 is on the website, nvcc.edu. Just search student handbook and then click on student conduct and integrity. So if you are using these formal hearing guide, training guide that I passed out, I will also reference where that is in your guide. It's actually the first page of your guide. All the information also can be found on the website. So I'm going to take a moment just to go on the website so you can see for yourself where it is, okay? So if we're on the website, I would put in, we're at nvcc.edu, I put in student conduct, or you put in student handbook. Either one should get you to your desired destination. If you click student conduct, it takes you directly to here, the handbook that deals directly with a student conduct infraction. Once you get here, you'll notice a lot of different tabs, such as definitions. We'll talk a little bit about that. Our core values, interim actions, violations and sanctions, and the conduct process. All you need to do is click on one of those tabs, and it'll give you the information that we're going to discuss today. And for an example here, there's one of our core values, integrity. And then here's the rules that go along with integrity. As you see, we have 8 rules that are outlined with integrity. Possible administrative sanctions, minor, moderate, and major. Educational sanctions. And then it goes on to the next core value, community. Keep scrolling. You'll see 10 rules there. Respect. 9 rules there. Accountability. 6 rules there. And academic integrity. So that's a little bit on the website. You just go right there and you click whichever tab you need to find information to, and it's all right there online. So back to our quiz. Number 2, according to the Student Code of Conduct, what is the burden of proof? This one's important. This one is an important one.
More likely than not.
And more likely than not. Okay, so you're thinking, all right, so of those 3 options, A, B, or C, which one? C, preponderance of the evidence, okay? Anybody else? What other options, what other answers? Okay, clear and convincing was your answer, so letter B, okay? Any other guesses out there?
I think it's C.
C, all right, so how many of you by show of hands will say it's C? Okay, preponderance of evidence. All right, so according to our code of conduct, the answer is C, preponderance of the evidence, 51%. So if you have your training guide here that print off, it's on page 3. It'll be under the conduct process. And what you'll see under the second note there, burden of proof, in bold, it'll say preponderance of the evidence. Very important that we understand this, that it's more likely than not, because that's the standard that we're using. A lot of times and that's just what we use here at our college. Different colleges have different standards that they may use. Here at Nova, no matter what campus you're at, we use preponderance of the evidence standard, 51%. So basically, if you put in layman's terms, you're thinking, is it more likely than not than that X occurred? So let's say Bobby stole Susie's iPhone. Bobby has to prove that he stole Susie's iPhone. Susie has to prove that Bobby stole her iPhone. The standard is more likely than not. So you say, more likely than not, from what I've heard today, do I think Bobby stole Susie's iPhone? If the answer is yes, do you find him responsible? If you go, I'm still not sure, then you find him not responsible. To kind of clear your conscience, I want you to understand, just because you do not find them responsible or not responsible doesn't mean they did or didn't do it. So sometimes you're like in your gut, I think the student did it. But you're looking at the evidence and you're listening to their testimony, you go, you know what, it's 50-50. You have to find them not responsible. Now, if it's 51-49, that's more likely than not. That's what we're talking about here. If you say, the character of this witness, what they're saying, I think it's more likely than not that they did it. That's our standard. That is the standard that we are supposed to be using, preponderance of the evidence standard. Any questions about that? Let's go to number 3. The burden of proof rests on which party? A, the complainant, B, the respondent, or C, both, the complainant and the respondent? How many would say A? Let's show of hands. Okay, 2. How many would say B, the respondent? Okay, how many would say they both need to prove it?
Yeah, they both.
All right, the correct answer is A, the complainant. I always say it this way, we live in America, and in America you're innocent until proven guilty. And same thing here at the college, you're innocent until proven responsible. And the person that's proved responsible is the complainant. So the complainant is the person who's bringing the complaint. So if Susie, if she's accusing Bobby of stealing her iPhone, well, Susie, you got to prove it. Bobby does not have to prove he didn't do it. Bobby can come to the meeting, say nothing. Doesn't mean he's responsible. Susie has to prove that Bobby stole her iPhone. Now, if Bobby doesn't come to the meeting, does that maybe hurt his case? Well, absolutely, because if Susie brings this really great case and explains how Bobby had it in for her and how Bobby was the last one seen with his iPhone, and she brings a witness like, yeah, I saw Bobby with her iPhone, he picked it up, and then Bobby's not there, well, you're going to conclude more likely than not, yeah, he's the last one with it, he picked it up, he's responsible. Now, if Bobby were to come in and go, yeah, I picked up her iPhone because it was about to get wet, I put it right back in her bag, and I talked to Jimmy about it, and Jimmy saw me put it back, and then the professor saw me do it as well, then it's like, oh. But we got to understand, Bobby is not responsible to prove he didn't do it. Susie has a responsibility. The burden of proof is on her. She must prove that Bobby stole the iPhone. Any questions?
So say for example, he's proven guilty, but he wants to appeal it.
Okay.
Is that when he needs to prove that he is not guilty?
Okay, so appellate rights. We don't spend a lot of time talking about appellate rights, since you guys really won't be ever hearing a case of appellate rights. What happens in our process is they go through the formal hearing. That's what you hear. You make a decision. You send that decision of responsible or not responsible to the dean of students, and then and with your recommendation of what you think should happen, the dean of students sends out a decision to Bobby. And so let's say you found Bobby responsible. He didn't show up, and Susie gave you this great story, and you're like, all right, yeah, he did it. He's responsible. Bobby gets the email from dean of students saying you were responsible for theft, for stealing, and whatever the sanction is. Let's say Bobby doesn't like that. He can appeal. The appeal will go to the provost. And we can look on the website right now, and they'll tell you the 3 criteria for appeal. So if we scroll down here to the conduct process, you'd see step 1, informal. Step 2 is what we're talking about today, formal. And then we will scroll, and we should see the appeal process here. Step 3, appeal. And so it gives the guidelines for appeal. And so they would have to use one of these 3 reasonings here. A procedural or substantive error occurred that significantly impacted the outcome of the hearing. Or 2, consider new evidence unavailable during the original hearing or investigation that could substantially impact the original finding or sanction. Or 3, the sanction imposed was substantially disproportionate to severity of violation. So Johnny has that right to bring that appeal, and he would need to do it under one of those 3 grounds. Great question. Any other questions?
After the hearing, you said we would, we give our recommendation, so would we not say at the hearing what our recommendation is?
Correct. So at the hearing, you give your recommendation. So to be a little more clear.
But not to the student.
Correct, not to the student. So what happens at the hearing is you hear both sides. Both sides have the opportunity to bring their witnesses, their facts, and to dialogue and explain their side of the story. After you've asked all the questions you have, you dismiss the students, and then you as a committee, so it'll be a faculty member, staff member, and student, you guys decide with majority vote wins who are not responsible of what they're being accused of. After that, you guys as a group determine what sanction do you want to give them. So as we looked earlier, we saw the sanctions went from minor to major. So you say, all right, well, we use a moderate infraction. So that could be anywhere from a warning to deferred suspension. You figure out which one you're going to pick. And then educational sanctions. Because this is, we don't just want to punitively sanction a student. We want to educate them if possible to say, hey, what type of educational sanctions can we give? If it deals with theft, like in this analogy, restitution is also part of our educational sanctions, and it's not inappropriate for you to recommend that. I generally do. Anytime someone steals something that's proven, I recommend restitution. That decision, restitution. So if you stole $20 and you're proven responsible, part of the sanction I have is you must give the $20 back. So once the chairperson will fill out the form that goes along with it. And after the chairperson fills out the form, they'll send it to the dean of students. The dean of students will read it over. Here's one thing you want to make sure you remember. According to the code of conduct, the hearing board determines whether the student is responsible or not responsible. There's nothing the dean of students can do about that part. So it's very important that you use a good justification and to the best of your knowledge, you get that right. that you use are more likely not standard, and you say responsible, not responsible. Now, with your recommendation of the sanction, so sometimes you'll say, hey, they're responsible, we want them expelled, they should never come back, and they need to do 1,700 hours of community service just because we need to make sure they learned their lesson. These students may look at that and go, okay, well, we're not going to expel them, we may suspend them, and we're not going to do 1,700 hours. Okay, so just make sure you understand your decision whether they're responsible or not responsible. That's the decision. The recommendation you're making is the type of sanctions. So that would be anywhere from warning to expulsion and any type of educational sanction. Any questions about that?
The dean of students could also have a more severe sanction than what we said as well.
That is correct. So when you make your recommendation of sanctions, so let's say you say, we found the person responsible, he stole her iPhone, and well, we just think it should just be a warning. Just a warning and an apology letter. The dean of students may look at that and go, okay, he's responsible, but no, I'm going to put him on deferred suspension, and he's going to give her a new iPhone. So those things are possible. But the whole point of your role is to look at the information and to make a decision more likely than not, are they responsible or not responsible?
So I have a question. So if the dean say yes, he's responsible, he needs to give her, deferred suspension, he needs to give her an iPhone. He doesn't give her an iPhone. Okay?
Well, if he doesn't do that, then there's another sanction in the code of conduct. The question was, what happens if you sanction a student and they do not go through with their sanction? So in this context, Johnny is sanctioned. You got to give her iPhone back or give her a new iPhone. And, that's a major part of what he needs to do back. And he goes, yeah, whatever. There's generally a time frame that you put to say, hey, you must get this done by this date. So if a student does not do it, there's a code of conduct violation that says failure to comply with the directions of a NOVA official. They will get a new sanction in which they will be charged with failure to comply with the NOVA official. They would have their due process rights. They'll be able to come in and explain either I did what you asked me to do and here's the proof, or no, I didn't do what you asked me to do. And then that will go through conduct process. And they'll either say, yes, I did. And it will be interesting. They say, yes, I did, but they can't prove it. Or they'll say, no, I didn't do it. And they say, no, I didn't do it. Or in this context, they admit that they didn't do what you told them to do. The dean of students will give them another sanction. And so it's really upon the student whether they're going to follow through, but the dean of students can hold them accountable. So it's not like, hey, we tell them they have to do something, and if it doesn't happen, oh well. And especially in cases like this, so you say theft, let's say the dean was gracious and gave the student deferred suspension, which is basically one more thing and you're out of here, buddy. And then he doesn't do whatever the sanctions were. So let's say it wasn't just giving back the iPhone. Maybe it was 20 hours of community service. Let's say he did 10. He didn't do any. And the due date came up. The students looks at that. They will say failure to comply with the direction of NOVA official, put it through the process. And in this case, if they're found responsible, they'll be suspended. Now that's the law and letter of how the code of conduct is written. Sometimes you have softies like me who don't always do it exactly like that. But there are times in which they don't obey, and so this is what the dean of students can do. What's the purpose of this? What's the whole purpose of the student conduct panel? Another way to ask the question is, what's your role? What is the role of the formal hearing panel? The answer is on page 3 at the top. Correct. So it's number 1 there, which is listen to the incident, ask questions, determine facts, and review the evidence presented. Then, number 2, the panel is tasked with rendering a determination of responsible based on the preponderance of the evidence. In the event that the student is found responsible for the charges, the panel will recommend sanctions to the dean of students. So basically, this is your job description. So every time you apply for something, you're like, oh, what's the job description? This is your job description. These are the things you will do when you sit on a formal hearing panel. You're going to listen. That should be the first thing you do, is you're listening to both sides. You're going to listen to the incident. You're going to ask questions. You're going to ask questions of both sides. So, you should be able to tell me everything about the case without the student sitting there. If you find there's some part that's fishy or some part you're like, I don't really understand, that means form a question, ask them a question about it. Determine the facts. So you're going to understand. You're going to hear 2 sides. And sometimes those sides of the stories are totally different. And you have to do the best you can to figure out what are the facts. They both have their perspectives. It doesn't mean that either one's lying. Now, they both could be lying, neither one could be lying, but that's their perspective. You have to figure out what really happened to the best of your ability. And then you review the evidence that's presented. So generally what will happen in a formal hearing is you have evidence before you get there. You'll have statement for records, you'll have pictures, maybe video. You can review that information as well. And then you will make a determination. Any questions?
Now, when it comes to asking questions, let's say the student did steal and it's on video, and now they're arrested and other things, are we allowed to ask questions that pertain to, I'm not asking correctly, to the arrest, or what, like, so they got arrested and they had to go to trial? Are we allowed to ask questions pertaining to that, or do we have to stick with just the evidence of what happened to Nova?
Great question. So if it's a case in which it overlaps with a law enforcement case and they're taken to jail or going to court, can we ask questions about that? We can ask questions about anything that deals with our case. So the direct answer to that is yes. So if I know Johnny also was charged, Johnny, what was the outcome of that hearing? Now, I will tell you this, and more likely than not, you're going to have your conduct hearing before the courts make a decision. Sometimes you do, sometimes you don't. But more likely not, you are. And you got to remember, Johnny doesn't have to answer you. So you can ask any question you want. Johnny says, I prefer not to answer. And that's that. Any other questions?
I've never had this happen, but I'm just curious, what if a student, the accused student, was found not responsible? Have they ever come back and said, that claimant has defamed me?
Yeah, I haven't had that one yet. I haven't had that one yet. The thing that would be closest to our code of conduct, the question is, let's say you have a student who's accused of stealing and they're found not responsible. Do they ever come back to the code of conduct or dean student's office and say, hey, I want to press charges on them because they defamed my character? Every charge has to be based on our code of conduct. The closest thing to that would be deception. But yet again, they would have to prove deception. So like I said before, let's say you have a case of Sue Beth, accusing Johnny of stealing her iPhone. He was the last person she saw with his iPhone, so it was a good assumption. Doesn't mean that she intentionally deceived us. Because when Johnny comes back and goes, yeah, I held her iPhone, I put it back down. The teacher told me to put it back down. Jake was close to her backpack when I left, but I don't know what happened then. Well, that's context she didn't know. So did she intentionally deceive or try to hurt him, or did she just give the report of what she had? There's two differences there. But to answer your question directly, a student could come back and say, I want to make a countercharge that this person is being deceptive. And then it would be their responsibility to prove that this person intentionally knew what they were saying was wrong and it was a lie. And they deceived you. They attempted to deceive them to hurt them in some way. Haven't had that happen though. Most students, they're not going through that. According to Student Code of Conduct, who qualifies as a student? This is very important. If you're going to sanction a student, can you know as the person in front of you considered a student?
Anyone that's applied to the school and is enrolled in classes, full-time or part-time. But I know number one says, where is it?
Maybe isn't it even after they've been a student for like 5 years or something?
3 years.
3 years.
3 years.
Yeah. So this one is one of those that you really got to know. That a person's a student if they have applied to our college and have registered for classes. And they are a student until their last enrollment plus 3 years. So I always explain this way. Someone can do awesome here at Nova, graduate from Nova, go on to their dream college within 2 years, graduate from their dream college. They're accused of violating our code of conduct. That's not 3 years. That's 2 years. They're still our student. And so they would still be given the due process rights that's guaranteed to them by our code of conduct. See, this is why that's why this is important. Our students have due process rights based on our code of conduct. Our community members do not. So if you're a community member and you're not a student, we could ban you and say, hey, look, you are doing X, Y, or Z to hurt our population. There is no due process. There's no conduct hearing for them. We have no jurisdiction over them. But if you are our student in the time frame that we say you are a student, these rules apply to them, and also the rights in these rules apply to them.
Even though they're just out in the community, they can still be considered.
Correct. And so if we don't follow this process that we would do for any other student, they can appeal and possibly win because we did not get them their due process rights. OCR, they're really big about that. So we want to make sure we give all of our students. We want to make sure we follow our policies. And when our policies say they're a student, They get the same rights as anyone who's sitting in your classroom.
So I'm a student. I've gotten my associate's degree. I'm now in another institution 1 year later, and I have been accused of something, and I have been found responsible for that. What is the obligation of our college to tell the current institution where that student is?
Great question. Question was, if you have a student, they graduated from Nova, they went on to their dream school, and they were found a year later, they were found in violation of our code of conduct, what is the responsibility of our college to inform their current college of what happened? That's a great legal question. So I'm going to leave that one in there and say, hey, call Donna Patchett. Because you want to make sure you call legal, and we generally would. So I would say it's a case-by-case thing. It depends on what is. And we would talk to legal, and legal would tell us what's the best route to do. If it dealt with a safety issue, then then you're dealing with FERPA and the release of information that we can use. But you always want to check with legal before you just say, hey, they were found responsible of smacking a kid. Just thought you should know, and then they come back and sue you because you violate their FERPA rights. You don't want that. So you'll never be placed in that situation. That's the great news today. You'll never have to worry about that. The dean of students could consult with legal, and then legal would let us know what's the best part of action for that.
So if I'm understanding right, we don't normally notify the other school when a student does something here. No.
It depends. It depends.
on what it is.
It depends. You'll never have to worry about that. You'll never have to worry about that as a formal hearing panel. As a dean of students, you would always consult with legal to say if you need to release that information, because there's certain aspects of FERPA that allows you to release information, and legal knows all the ins and outs. And so we would contact them and say, hey, is this something we need to release to this other school? The general answer is no, we wouldn't do it. But the real answer is case by case, and you would always consult with legal because you don't want to get sued. Great question. Describe the conduct process. This one is just in your own heart. How would you describe the process? So if you had to sit before just a student in your class and, hey, here's how conduct works. And basically the answer is this. Conduct process is pretty simple. As we looked on the website, it goes through what's the informal hearing part of the process. It goes through basically 3 steps here, and I'll go back and look at it. The conduct process. Step 1, the informal resolution meeting. I will say this, 90% of my cases are settled here in the informal resolution meeting. So an informal resolution is, Sue Beth accused Johnny of stealing the iPhone. I send the email out to Johnny. I let him know he's being accused of stealing an iPhone. Johnny comes in, he meets with me. In most cases, Johnny comes in and says, yeah, I did it. Okay, well, I need the iPhone. We need to make this situation right. Okay, no problem, 90%. But you're here today because the 10%. 10% of the cases, they say in this informal hearing, no, I didn't do it. And so if a student does not take responsibility and you believe it is enough information to say, hey, it could go either way, it will go to the next step here, which is the formal hearing process. At a formal hearing process, the student who's being accused has 2 options. They could either want the case to be heard by the dean of students, in which the dean of students would meet with both students and their witnesses, and the dean of students will make a decision, or, while you are here, the formal hearing panel. I will say here at Annandale, most of our students choose a formal hearing panel. And as a formal hearing panel member, you do what we talked about before. You listen, you ask questions, you'll make a determination of responsible or not responsible. And then step 3, as we discussed earlier today, is the appeal process. Not many students appeal, but it is their right. And so what happens is when they get a decision letter, it will say, if you choose to appeal, here's a link to that process. It sends them right to this page, and then they can fill out the appeal based on this information here, and it will go to a provost. And the provost makes a decision, her decision or his decision, depending on where you're at, it is final. All right. So according to Student Code of Conduct, why do we impose disciplinary sanctions? This will be on page 2 if you have the handout. It's under Ready to Serve Violations and Sanctions if you're on the website. It gives you 5 reasons why we give sanctions. And so you want to kind of build that into your philosophy of, all right, here are the 5 things I should be trying to correct with my sanctioning. So you provide fair and just consequences for misconduct, protection for the safety of the college community, enhance the academic environment, discourage future violations of the code of conduct, or contribute to the growth and development of that student. And so those are the ideals that you're trying to put into your decisions, those 5 core key ideals. List of three of the 5 NOVA core values. As we looked at earlier, each one of our rules is one of our core values. And under those core values, you have like 7 or 8 rules that goes along with it. So integrity, respect, accountability, community, academic integrity. Those are our 5 values. We expect every faculty, staff, and student to go along with these 5 values. And then we explain, when we talk to a student, go to the website and read what each rule is that's under those values. The issue is if you obey those 5 values, you'll never have an issue with student conduct. And that's why the majority of our students don't have an issue with student conduct. The problem is when you're accused of violating one of those values. And so to just be aware, those are our 5 core values. The formal hearing happens whether or not the student attends the hearing. What do you think? How many would say yes? The formal hearing will happen whether the student attends the hearing. So you can have a formal hearing and one of the students or both of the students does not attend. Do you still have the hearing? Yes, you do. So remember, the hearing is their opportunity to present their side, their facts, their witnesses. It's not a requirement for them to come. They don't have to come. I'll also say this. Sometimes they will provide you statement for record, facts, and they don't intend to come because they expect you just to look at their statement for record and use that. Some students are like, I don't want to go through this process, but here's all the information. I think you have enough to make your decision. So do not hold it against a student, whether they are a respondent or a complainant, by not coming. One of the worst decisions you can make is, oh, they don't take this seriously because they didn't come. They take it seriously because they went through the process. They accuse the student of violating code of conduct, and if they've given you information, they're expecting you to use that information. And so remember, not all the information you get is verbal. A lot of it will be statement for records, video, audio, text messages. Use all the information at your disposal to make a good decision. Number 10, according to Student Code of Conduct, what are the 3 levels of violation? Yes, minor, moderate, and major. Dumb, and dumber. That's not one of them. Minor, moderate, and major. One of the great things about our new Code of Conduct is that you can either determine 1 or 2 ways, and it kind of helps you make sure that we're doing the same thing across the board at all campuses. Is minor tells you, all right, if you think this is a minor issue, that means you can either give them a warning or probation. If you think it's a moderate issue, probation, deferred suspension. If you think it's major, suspension, expulsion. And so if you're like, I think they should be suspended, then you'll say, okay, make an argument that it's a major issue. I think, yeah, they should get a warning. Okay, make an argument that it's a minor issue. Now it puts us all on the same page at the college to say, hey, if this happened at Manassas, they thought it was a moderate issue because of this reason. And then it says, well, they gave them a warning, you gave them probation. It's allowed within that bucket. And so it's okay if someone were trying to make the argument that the decision you made was substantially unfair, which is one of the reasons for appeal, they can make the argument, and then we can look back at our standard and say, was it? And be consistent. So they can say, hey, I had a friend in Manassas, he did the exact same thing, he got a warning. I got probation. Well, if both of you thought it was a minor issue, and in a minor issue bucket, you anything from warning to probation, you both could be right. And you both are right, our policies.
So how do you determine where the process is what campus the process is gonna take place on? Say, for example, I'm a Loudoun student, but I take classes on the Annandale campus, and I did whatever I did on the Annandale campus, and I was accused on that.
Generally, it's the campus where you're accused, unless it's a cross-campus case, and then Dr. Harper would make a decision of how to handle that one. And that's how it's dictated in our code of conduct. Last question. What questions should you be able to answer before making a decision?
Explain what happened. Who are the people involved, and explain how they're involved. When did this event occur? Where did this event occur? Motive, why, they can help them to substantially establish this happened.
Yeah. Who, what, when, where, why, and how. Got to be careful though. Why? The why question doesn't really help me understand whether they did it or not. The why gives me explanation. So a lot of times we hear the sob stories. You're going to hear them. And you have to remember that why does not determine your first answer. So, I stole from the bookstore. Why? Because I had nothing to eat. Would you find that student responsible or not responsible? Why? They just told you. They have nothing to eat. Yeah, we hold them responsible because they violate the code of conduct. Now, how many of us feel bad that they have nowhere to eat? All of us. Every hand's raised. We all feel bad. Now, that may go into your sanctioning of, all right, you're responsible, and they only stole a loaf of bread, so I'm going to give them a warning. But the mistake some people make is they have that bleeding heart. And so they go, oh, he has nothing to eat. We can't hold them responsible. It's not their fault. And like I said, you are responsible for this. If you mess up this, we can't overturn it. So if you find a student not responsible for stealing because they have a sob story, you're setting a terrible precedent. And so make sure that you use the code of conduct to determine whether someone's responsible or not. Who, what, when, where, how, those are the questions that determine responsibility. Why is a question that helps you determine the type of sanction. Why helps you understand, do they already have the developmental aspects that I was going to give them with my educational paper? Why helps me understand the context and sometimes the severity of an issue. So why is important? But why should never be used to answer the question responsible or not responsible. It can't help you. Why cannot help you on determining the first question you must ask. Are they responsible or not responsible for violating the code of conduct? Why can only help you when it comes to determining sanctions. Any questions before we close today?
I have a question about what if a student has been accused of something and the student was brought in to the dean of students and it was told that you did this thing. And the student just heard it and didn't say anything about it. The student was suspended, found out or suspended. Can a student be suspended without having any kind of, if they don't have any recourse, if they don't say, I didn't do this, or they.
All right, so question is suspension, how does suspension occur? So if you're accused of violating the code of conduct, you're going to get an informal hearing letter.
Yes.
In which you're told you need to meet with the dean of students to discuss this situation. It tells you what charge you have, and it will generally give you 2 days to schedule the meeting. So let's say the student doesn't show up, doesn't make a meeting. The dean of students will then send another informal hearing letter and say, your informal hearing is on this date at this time. Say student doesn't show up to that. According to our code of conduct, the dean of students can use the information that is present to make a decision. And so they can say, well, I have video, I have this testimony, that testimony. I think the student's responsible. They find him responsible, they suspend the student. The student can still appeal the decision and take it to the provost. But to answer your question directly is yes, you can be suspended without even showing up to your hearing. Because remember, you're not required to come to your hearing. And if I'm accused of something, it's not my responsibility to prove I didn't do it. Now, is it in your benefit to come? In most cases, yes. But if you don't come, they're going to use the information I have available, more likely than not standard. They're going to make a decision if you don't come to your hearing. And that's your informal hearing. Any other questions? Yes.
How much do you work with student schedules? Are you just working around the class schedule? When you're
It depends. It depends on each conduct officer. My personal preference is I just work around their class schedule.
okay.
But how I generally do it is I send an email, the informal hearing letter. It lets them know what they're being charged with. It tells them you have 48 hours to schedule an appointment with me. And then I have my assistant call them and get them on my calendar. So that we call them and say, hey, you need to meet with me. So that way it worked around their schedule because they don't want to schedule the appointment. But if I have a student who's dodging me, who's like, hey, I sent this, a couple of days ago, you never responded, I will, by our code of conduct, we have to have a 5-day notice. So I usually give a 7-day notice and say, hey, your hearing's gonna be on this day, this time. I try to do it right after a class. And then
What if it's like the formal hearing though?
the formal hearing. So with the formal hearing, generally we do them outside of class, but generally in their informal hearing, they know it's gonna go to a formal hearing because they're saying,
Okay.
I didn't do it. And then I say, well, are these times available for you?
Okay.
And in their formal hearing, they will get a letter, 7 days, or about 5 days, 5 business days before the hearing, and it will tell them the day, time, etc. And if they need to change that, they need to call immediately. It says within 24 hours. It does tell them that changes are generally not permitted. But like they said, hey, I'm in the middle of a court case, or my mom is, we're going on vacation this week, then we may prolong it. But the moment they get that formal hearing notice, they know the date and time, and it's their responsibility to call and say, hey, can we reschedule?
Do you ever make decisions just based on word of mouth? Say, for example, I says, Kelly took my purse.
Question is, do we make decisions based on word of mouth? You're responsible to make decisions based on more likely than not. So you judge the credibility of the witnesses, credibility of the statements, and did it more likely than not happen by your best judgment? And then you have to, you write about that. You write about, here's why we believe this happened more likely than not. So credibility of witnesses is important. I think in the, in the script for the formal hearing, it says a pattern of lying can be used against you. So when you have a student in there, you're like, you lied about this, lied about that. Yeah, and then you say, well, credibility of witnesses, and that's what your whole case is dependent upon. Yeah, that could be used against them, and that's what it says in our formal hearing guidelines. Any other questions? Great questions, by the way. All right, well, thank you guys for attending today, and we will have another training for a mock hearing. So if you've never heard a hearing or never participated in a mock hearing, you may want to attend those trainings so you can see. I like to make things black and white. You're probably feeling right now, man, I could do this. And talk to anybody who sat on the hearing board, man, it's not black and white as he makes it sound. It is a lot of gray that uses your best judgment. But thank you for coming today, and I hope you have a great day.
Thank you.
Was everyone here on Annandale?